every female in India, especially Hindu female, should mandatorily write a will. Do you know who said? Yes, Supreme Court gave a very strong direction to every Hindu female. So let's see the scope. Snida Mehra versus Union of India, very recent judgment. It was a writ petition and Supreme Court very clearly gave a direction. Please, we urge every Hindu female in the country to write a will irrespective of your age. Hindu Succession Act 1956. So Hindu Succession Act 1956 is giving you a direction how normally a male or a female, when they die intestate, that means without writing a will, how their assets will be distributed among the legal heirs. Now let's see the scope of Hindu female if she die intestate. So section 15(1) and section 15 subsection 2 covers these two scopes. Section 15(1) covers the general property. So let's see how the property distributions happen for a Hindu female. Whole property, her entire property is distributed into two categories. One is general property, and another property is basically inherited property, either from her father or mother or either from her husband. So, okay, now for the time being, the second category, the inherited property, we can keep it aside. Now let's see the general property. Every property of a Hindu female covers under section 15 subsection 1, including she self-acquired property. The scope is section 15 subsection 1 is giving you 1, 2, 3, 4, 5, almost 5 level of legal heirs. Who is the first legal heir? Her husband and her children. Okay, they are the first rights of inheritance. Second, in the absence of a husband, in the absence of a children, second category is legal heirs of the husband. Exactly, the legal heirs of the husband is the second rights on a Hindu female's property. And the third category will only go back to her father, her mother, those categories. So unfortunately, legal heir of the husband is a very wider scope that includes her husband's mother, siblings, father, all those legal heirs will come when it comes to a Hindu female's property distribution. Now, second category, those inherited property, right? Section 15 subsection 2, only those category of assets is also classified into two. Either if she inherited anything from her father or from her mother, the entire property will go back to her father's legal heir. Okay, note her father's legal heir, not even go back to her mother's legal heir. If anything she inherit from her husband, those property will only go back to the husband's legal heir. So summary, a Hindu female's property is into a general property. That general property, the first rights is basically husband and her children, and the second right is basically the husband's legal heir. If anything she inherit from her father only, it will go back to her father. If she anything inherit from her husband, it will go back to the husband's legal heir. Supreme Court is giving a very clear direction to every Hindu female in the country, irrespective of your age, please write your will. What I would like to clarify with my personal experience, law is very clear. When you go to the court, that court case, all those things will take years to get you a particular verdict. In this case, it took almost 5 years to get you such direction. So why you waste time in the court? Please write your will immediately because the law is giving you a right, okay, to write a will. So use that option is the first priority instead of going through all this rest of the other formality, because as I strongly say, sentiment, sympathy has no role when the law is clear. Please write your will.